I'm introducing Professor Brittney Wilson she is an associate professor of law and director of civil rights and disability justice clinic at New York Law School. Before New York Law School, Professor Wilson was a staff attorney at the National Center for Law and Economic Justice, where she litigated disability rights and criminalization of poverty cases concerning the issuance of excessive fines and fees in the communities of color. Before NCLEJ, Professor Wilson was a Bertha Justice Fellow at the Center for Constitutional Rights, where she litigated discriminatory policing and abusive immigration detention practice cases. Before CCR, Professor Wilson was a Marvin M. Karpatkin Fellow in the Racial Justice Program and in the National Office of the American Civil Liberties Union, where she litigated a range of racial justice issues, from the school to prison pipeline to the fair housing and inclusion in higher education. Born with cerebral palsy, Professor Wilson has written and spoken extensively about disability and the interaction of race and disability. Her scholarly work has been published in the University of Pennsylvania Law Review and the Journal of Legal Education, and she was recently selected as a health law scholar by the American Society of Law, Medicine, and Ethics and St. Louis University School of Law Center for Health Law Studies. Also a poet and creative writer, Professor Wilson's creative writing has been published or featured in outlets such as The Nation's Magazine, Long Reads, This American Life, and the HBO's Brave New Voices. She received her BA from Howard University and her JD from the University of Pennsylvania Law School.
Hi, everyone. Thank you so much for having me. I want to first thank the editors of the Western New England Law Review, especially Andrew and Kim and Shanice. I think I got a couple emails from, or anyone else that I left out. I really appreciate you having me. In the spirit of access, I'm going to begin by giving a visual description of myself. I'm a Black woman with my hair in twists. I'm wearing Black rimmed glasses and a printed pink, gray, and green blouse. I'm in front of a virtual background that says New York Law School. And I'm going to begin my remarks by explaining a little bit about what I'll call my overall scholarly and advocacy agenda, because I'm a clinician. And you guys know what that means. You're law students, but just in case there's anybody that doesn't, that means that I work on cases with law students in order to train them how to be attorneys. And so I do both litigation and social justice advocacy and scholarly work. And I like to think that both of those are informed by my own experiences as a Black disabled woman. And so I know that the theme of this symposium is race in the law and the intersection of race in the law specifically. And I think oftentimes when we talk about terms like intersectionality, coined by Kimberly Crenshaw, scholars like Kimberly Crenshaw, we think about the overlap of identities. We think about people who have more than one specific aspect of their identity, being a woman and a person of color, or being a disabled person and a person of color. We think about it in terms of representation, or even the more colloquial notion of the phrase, if you think about an intersection as like a corner, a place where two things meet. But I think specifically when I talk about race and disability, I'm not so much interested in it from a representational standpoint or a statistical standpoint. And what I mean by that is we know that people with overlapping identities exist. We know that disabled people of color exist. And we also know that many different issues affect people of color disproportionately. That's what I mean when I say I'm not so much interested in how race affects members of different demographic groups disproportionately, because we have tons of stories about that. We know that that's the case. So what I'm more interested in is how the law creates the categories of race and how the law creates the categories of disability and what the effects of those things are. So what the function of race is, what the function of disability is, and how those things interact. I hope that explanation makes sense. But I'm going to talk about that specifically in the context of one of my articles, Making Me Ill, Environmental Racism and Justice as Disability, which was published last year in the University of Pennsylvania Law Review. And it was part of a symposium. And just to give you a little bit of explanation, the theme of that symposium was the disability frame, which specifically meant how a range of people with diverse interests have used the category of disability to meet their needs and advance their right to live in the world, sometimes legitimately, sometimes not. So basically, the theme was how people have used the ADA, the Americans with Disabilities Act, or the notion of disability in ways that weren't necessarily designed to benefit the disability community. And so I chose to interrogate what I see as a theme of civil rights litigators and civil rights scholars who are frustrated with the difficulty of proving racial discrimination legally, specifically the requirement of proving intent to discriminate based on race, which is extremely, extremely difficult to do. And because of that difficulty, a lot of scholars have started to look to the Americans with Disabilities Act or a disability frame more broadly to challenge structural racism and other forms of structural harm. Because the idea is that in the racial discrimination context, you have to prove intent. Even if you're talking about disparate impact, there's no private right of action under Title VI of the Civil Rights Act of 1964, which leaves the enforcement of disparate impact largely to administrative agencies that don't always pick up that burden. And so civil rights scholars have said it's really hard to prove racial discrimination, and maybe we should look to another civil rights vehicle. And some of them have said that that vehicle should be the Americans with Disabilities Act, specifically because it has an affirmative mandate to address discrimination vis-a-vis reasonable accommodation or reasonable modification to discriminatory policies and practices. And so some scholars have said, so if you fit the category of disabled, then all you have to do, there's a affirmative requirement that your discrimination be addressed. And they think that that poses more of a solution than having to prove racial intent or having to prove discriminatory intent or having to prove disparate impact. And so because of this field of scholars who were positing this, I wanted to interrogate that question because I wanted to know, is it actually easier or better to use either the Americans with Disabilities Act or the disability identity more broadly to challenge racial discrimination, or are there implications for that as well? And my immediate inclination was that these scholars who were positing the use of the Americans with Disabilities Act or the disability frame more broadly weren't adequately taking into consideration the existence of people of color with disabilities and how disability functions politically as an identity in our society. And that's what I mean when I talk about the function of disability and the function of race. And so that's sort of a broad overview of what the goals of my article were. And I'm gonna talk to you a little bit more about the inspiration and what the article ultimately found. And so how did I end up doing this? So my background is in civil rights litigation. As you heard, it's not explicitly in environmental justice until a few years ago when I found out that National Grid was constructing a frac gas pipeline through communities of color in Brooklyn, starting in my hometown and backyard of Brownsville, Brooklyn. And so that is how I was actually accidentally pulled into the world of environmental justice. Literally, a group of my neighbors informed me about the construction of this pipeline and asked if I could do anything to help. And although I didn't have a formal background doing environmental justice work, I found myself in the midst of this world. And I had always sort of been interested in environmental justice. I never really had an opportunity to explicitly do that work. And when I explored the reasons for my own interest in it, it was sort of because of its connection to disability. Every time you hear about environmental justice, you hear about it in the context of the threat it poses to affirmatively disabling people, making people, quote unquote, sick, making people, quote unquote, disabled. And so always sort of had a tangential interest in environmental justice, but hadn't really had an opportunity to do that work until a couple of years ago. And so, long story short, my clinic in the National Center for Law and Economic Justice filed a Title VI complaint on behalf of communities of color in Brooklyn, challenging the construction and operation of that pipeline. Title VI is the Civil Rights Act of 1964, which prohibits agencies that receive federal funding from engaging in racial discrimination. And so that's how I got plunged into the world of environmental justice and that's what made me ultimately interested in addressing this question of whether or not disability or the Americans with Disabilities Act was a better vehicle for challenging racial injustice from this lens, through an environmental justice lens. And so as I started looking into these issues and doing my research, I realized that there was a social justice critique, a sociological critique among social scientists of disability being framed as both a fearsome villain and an innovative legal strategy in environmental justice campaigns. Social scientists were critiquing the use of disability as sort of this threat, this fearsome, horrible thing that results from environmental harm. And particularly environmental justice as a field where communities of color are disproportionately impacted and leading the fight. It gave me a space to explore both issues of disability, the affirmative disabling of people, and the existence of people of color in one fell swoop. And I realized through my research that even though we talk about environmental harm and environmental racism as something that affirmatively disables people of color, that people with disabilities, including people of color with disabilities, were also disproportionately affected by environmental racism and environmental injustice, because surprise, surprise, many disabled people are also people of color, and many disabled people are also low-income people who are disproportionately impacted by environmental hazards. And yet, despite the fact that I found that disabled people of color were disproportionately impacted by environmental racism and harm, they weren't largely the reason why people were using the Americans with Disabilities Act or the ADA to address issues of environmental injustice. And there's actually a critique that people with disabilities are often left out of environmental justice campaigns, even as disability is affirmatively used as a framing to challenge environmental injustice. And so exploring some of the reasons for that, it became clear that there is a relationship between environmental justice and public health, and specifically that environmental racism is often framed as the harm that results to communities of color in the context of public health, the way that the environment negatively impacts people's public health. And there's a history and a tension between public health communities and disability communities, because oftentimes in the context of public health, disability is framed as the thing we want to prevent, the thing we want to get rid of. We want quote unquote healthy communities. And so disability is often posed as the antithesis of that. We talk about that when we talk about the medical model of disability. That's one of the theoretical framings of disability. It's the idea that the disability itself is the problem. It's something to be fixed or treated or cured. And many advocates during the disability rights movement in particular tried to push a social model of disability where it's not the disability itself that's the problem. It's society and society's barriers and structures that actually disable people. So it's, to use a basic example, it's not the fact that someone can't get up the stairs that's the problem. It's the fact that the stairs are the problem, that the fact that there's no elevator, that's a problem. If there was an elevator, everyone can access the space. So it's not, the problem is not in the individual, it's in the environment. And so because of this difference in framing in the public health context of disability as the thing we want to prevent, the thing we want to cure, the thing we want to fix, there was this tension between public health that we sometimes saw play out in the context of environmental justice, because again, disability was the thing we should fear, the thing we don't want. And I say all of this while acknowledging that people have a right to live in healthy communities, right? People have a right to feel whatever way they feel about their bodies, to not want to be disabled, to not want to be quote unquote sick, right? So I'm not challenging people's individual feelings, but I'm challenging societal framing and the behavior and attitudes that can result from that societal framing. And so in light of these tensions between how disability is often used and discussed in the context of environmental justice, it became really ironic when you started looking into advocates saying that disability and the ADA should be used to address environmental injustice. And so the article specifically looks at two cases where advocates tried to use or used the Americans with Disabilities Act to challenge environmental justice, environmental injustice. And then I'll go on to talk about the implications of those attempts and what they mean for racism and ableism. So the first case that I looked at was Lewis v. Foster. And Lewis v. Foster concerned a community in Cancer Alley, Louisiana, which is miles of Louisiana between New Orleans and Baton Rouge, where there are tons of petrochemical plants and where so many people were dying of cancer that the community members nicknamed the area Cancer Alley. And in 1996, a petrochemical facility tried to build another facility in Cancer Alley, and the community organized in opposition to it. And ultimately, they filed a lawsuit under the Americans with Disabilities Act to try to stop the Louisiana Department of Environmental Quality from issuing a permit to the petrochemical facility to build another plant. And they filed this complaint under the ADA. Residents with asthma, cancer, and other conditions specifically sued to say that the building of this petrochemical plant would exacerbate their disabilities, their already existing disabilities. They were already disproportionately exposed to environmental harm in their communities, and they didn't want to make it worse, essentially. And I spoke to, for my law review article, I spoke to the person who put together the lawsuit, and I specifically spoke to them about why they chose to use the ADA and what led to their use of the ADA. And we talked about how difficult it was to bring race discrimination claims. And nonetheless, they still tried to do so in their complaint. And the defendants said, the issuance of this permit has nothing to do with race, for example. And through the attorney talking to people, they realized, they nicknamed the area Cancer Alley. Many people in the community were sick. Many people in the community had cancer and other conditions. And they wanted to figure out a way to tell that story, to sort of illustrate the concrete effects of racism, if you will. And they chose to use disability in the ADA to do that. And there was some people in the community sort of disagreed with that presentation. They were concerned about the reputation of the state of Louisiana having a civil rights lawsuit saying that they discriminated against people with disabilities. But that's the framing that they ultimately went with. And the attorney said, and I don't have the quote directly in front of me, but she was afraid of putting a quote unquote non-racial blanket over an inherently racial problem. And that sort of illustrates again how people tend to separate issues of race and disability, that thinking that because you're putting something in a disability lens, you're not explicitly addressing racial discrimination in that same context. Long story short, with that lawsuit, it wasn't ultimately litigated because the petrochemical facility withdrew its proposal due to community pressure. But what I talk about in the article is I analyzed the motion to dismiss that was filed, and how that illustrates that even though it's hard to prove intent, racial intent to discriminate in the context of racial discrimination, the disability has its own proof mechanisms that could also be equally problematic, including having to prove, quote unquote, a disability for the purposes of the ADA, and other things that I'll get into a little bit later. The second lawsuit that I talked about in my article was Baez v. NYCHA, where a group of residents of public housing in New York City, residents with asthma, sued over a lack of remediation of mold that they said was exacerbating their conditions, and that they said that they were denied a reasonable accommodation for their asthma. And I also spoke to the attorney who brought that case, who again talked about not only how difficult it is to bring racial discrimination cases, but specifically that environmental laws don't address these concerns because there aren't federal or local environmental laws that address indoor air quality, for example. And as he was sort of researching to figure out a legal hook to challenge landlords' lack of remediation of individual tenants' mold complaints on a systemic basis, he started to think about, what are the list of disabilities, and thinking about how he could think through a disability lens for this case. And ultimately, that case wasn't litigated because it was settled, but I think it also raises some interesting questions about the potential utility of the ADA, but also concerns about using disability for non-explicit issues that are not intended to benefit the disability community itself. And so ultimately, I concluded that there are some helpful legal reasons to use the ADA to challenge environmental racism, or racism more generally. And one of those is the narrative element, right? It requires the inclusion of people with disabilities as a legal necessity in your cases, but it also illustrates the relationship between environmental harm and race and disability in ways that maybe other vehicles don't. But at the same time, it sort of assumes that disability is less of a political identity than a racial identity is. And I think many people with disabilities would disagree with that assessment. It also assumes that um, people of color with disabilities don't deal with compounded effects, right? It assumes that you can sort of switch out one political identity, race, for another political identity, disability, and that doesn't account for the compounded effect of race and disability. There's a scholar, Saray Jarrell Johnson, who talks about what they call the paradox of Black disease, which is the stereotype that Black people are both so superhuman that they don't feel things and get sick and aren't harmed by things in the same way that other people are, but also that Black people are so inherently inferior that whatever disabilities or sicknesses they have are inherent to their physical selves, right? And so using disability to address issues of racial discrimination without having a full understanding of how race functions and how disability functions both separately and together in our society can be limited. And so that was the analysis. that I did in my article, and I'm gonna stop there. And thank you so much again for having